She has a business card. It says, Vice President, Family Office. She has an office, 22nd floor, glass walls, her name etched into the door in the same typeface as her father's. She has a salary, a title, a seat at the table when the family's holding company reports quarterly numbers. What she does not have, what she will not have for 8 more years, is the ability to move a single dollar of the fortune that carries her name without someone else's signature. Not her father's signature, necessarily, not even a person's signature. Often it's a trust document drafted before she could walk that simply will not release capital to her control until she turns 30. The lawyers call it a distribution age. The family calls it when she's ready. Nobody calls it what it structurally is, a 22-year waiting room with a very good view. This is one of the most consistent, most deliberately engineered, and most rarely explained patterns across old money families. And it is not an accident, and it is not cruelty, and it is not simply distrust of the young. It is architecture. It is actuarial. It is, in most cases, built by people who watched a fortune get destroyed by someone who got full control at 21 and learned everything the expensive way. Today, we're opening the file on the title without power structure, why it exists, how it's built, what it costs the people living inside it, and why the age nearly always lands somewhere between 25 and 35, almost never earlier. This isn't hidden, it's just never taught. If you've ever wondered why the children of wealthy families seem to spend their 20s in expensive-looking jobs that don't actually seem to do anything, this is the video that explains the mechanism behind it. Subscribe now, because by the end of this one, you'll never look at a 26-year-old managing director the same way again. The title trap. What the job actually is. Let's start with what the title is for, because it is for something. It is not decorative, even though it functions decoratively to outsiders. In most multi-generational wealth structures, an heir's early title, Vice President of the Family Office, Director of Philanthropic Initiatives, Associate at the family's private investment vehicle, serves 3 purposes, and control of money is not one of them. Purpose 1, identity scaffolding. A 23-year-old with no title and unearned wealth is, socially and psychologically, in freefall. They have no organizing story for who they are. A title gives them a desk to sit behind, a reason to wake up, a sentence to answer, "So what do you do?" with at a dinner party. Old money families are unusually attentive to this problem because they have watched, generation after generation, what happens to heirs who are simply handed money and nothing else. The clinical term researchers and family wealth advisors use is affluenza, or, more precisely, a failure of what psychologist James Grubman calls immigrating from a mindset of wealth creation to a mindset of wealth preservation. The heir never develops any working relationship to money because they never had to. The title is the family's attempt to manufacture a working relationship where organic necessity would otherwise have created one. Purpose 2, apprenticeship without authority. The title puts the heir inside real meetings, next to real numbers, watching real decisions get made, without letting their hands touch the controls. This is closer to how a surgical resident operates under an attending physician than how an actual executive operates. They observe. They draft memos nobody is obligated to read. They sit in on board calls where their vote, if they even have one, is structurally outweighed by trustees, outside directors, or senior family members who hold veto power written into the family's governance documents. It's real proximity to power with no actual lever to pull. Purpose 3, and this is the one families almost never say aloud: evaluation. The title-holding years are a probation period. The family, and specifically whoever controls the trust or the holding structure, is watching to see whether this person can be trusted with actual control later. Do they show up? Do they read the materials? Do they ask good questions or perform enthusiasm? Do they treat staff, assistants, drivers, the people who actually run the family office day to day, with respect or with entitlement? This evaluation period is rarely written down as such, but multiple family office advisors and governance consultants describe it in almost identical terms. The title years are an unpaid extended job interview for a job the candidate was born into and cannot actually be fired from, but can absolutely be sidelined from. Here's the detail that surprises people. This titled but powerless period is not really about age at all, even though it's usually bound to an age. It's about a track record. The number 30 shows up so often across families specifically because it's roughly the length of time it takes to generate a track record long enough for the people who currently hold power to feel confident releasing it. Which brings us to the actual machinery underneath the title. The machinery, how no power is actually engineered. The title is the visible layer. Underneath it is legal architecture. And this is where the real answer to why can't she just take control lives. The trust structure. Most first-generation and second-generation wealth in old money families isn't sitting in a checking account with the heir's name on it. It sits inside trusts, legal entities that hold assets on behalf of a beneficiary, but are controlled by a trustee, who may be a bank's trust department, a law firm, an independent professional trustee, or in some structures, a trust protector whose entire job is to oversee the trustee. The person who created the trust, the grantor, usually a parent or grandparent, writes the rules for when and how the beneficiary gets access, and those rules can be almost infinitely specific. Distributions of income only until age 25, then 1/3 of principal at 25, 1/3 at 30, remainder at 35, is an extremely common structure, sometimes called a staggered distribution trust. We covered the broader architecture of these vehicles in our video on the buy, borrow, die mechanism. Go check that out if you haven't, because it explains how families avoid ever technically selling assets the trust holds, which is a separate but related piece of this puzzle. The incentive trust. Some families go further and tie distributions not just to age, but to behavior, a structure known as an incentive trust. Money is released when the beneficiary graduates college, matches earned income dollar for dollar, stays sober, holds a job for a defined period, or hits some other family-defined milestone. Incentive trusts are controversial even among the estate planning attorneys who draft them, because they can be read as either responsible stewardship or a permanent, humiliating leash. And we go deep into that specific tension in our Black Sheep Protocol video. The family limited partnership or holding company. For families whose wealth includes operating businesses, real estate portfolios, or large investment vehicles, control often runs through a holding entity, a family limited partnership, FLP, or a private holding company, rather than directly through personal ownership. An heir might hold units or shares in this entity that represent significant economic value on paper, while voting control sits with a general partner or a managing member position occupied by the parent, or by a professional manager the parent appointed. The heir can be extraordinarily wealthy on a balance sheet and have zero voting rights simultaneously. This is not a loophole. It is, in most cases, the explicit design goal, separating economic benefit from control so that the fortune can't be mismanaged, sold off, or fought over by multiple family members with competing agendas before there's any framework for resolving those fights. The family constitution and family council. In the more sophisticated multi-generational operations, the kind we detailed in our family constitutions video, there's often a governing document that isn't legally binding in court, but is binding in practice because the family has agreed to treat it that way. This document frequently specifies not just distribution ages, but readiness criteria, education requirements, a mandatory period working outside the family business first, sometimes a formal application process where an heir has to present a case for entry into a leadership role, evaluated by a family council that can include non-family professionals. The board seat that isn't a vote. Many young heirs are given board observer status. They can sit in the room, see the materials, ask questions, without an actual vote. It looks to an outsider exactly like being on the board. It functions completely differently. Put all four of these together, and you get the actual mechanism behind job title, no real power. The heir sits inside a structure: trust, holding company, family constitution, board, where every layer of control has been deliberately separated from the layer of economic benefit and deliberately time delayed, usually to somewhere in the late 20s to mid-30s. This is exactly the kind of mechanism that never gets explained anywhere else. Comment below with the age you think is fair for someone to get full control of significant inherited wealth. I read every single one of these and they consistently surprise me. And if you want the deep dive on how the trust side of this works specifically, our video on the buy, borrow, die strategy is linked in the description. Why 30? The logic behind the number 30 is not a magic number, but it is a recurring number, and the reasons it recurs are worth taking seriously because they come from three different directions: neuroscience, actuarial history, and a specific, well-documented family failure that became a cautionary tale across the entire wealth planning industry. The neuroscience argument, carefully framed. Estate planners frequently cite research on prefrontal cortex development, the brain region responsible for long-term planning, impulse control, and risk evaluation, which continues maturing into the mid-20s for most people. This is genuinely established developmental neuroscience. What's less rigorous, and worth flagging honestly, is how far some advisors stretch this to justify a specific number like 30 rather than 25. The science supports not 18, probably not even 22, much more confidently than it supports any single precise cutoff. Families that lean hardest on the neuroscience argument are often using it as a respectable-sounding justification for a number that was really chosen for other reasons. Reasons we'll get to. The actuarial and historical argument. Insurance actuaries and estate planners who've studied multi-generational wealth transfer point to something more empirical, the age at which someone's decision-making track record becomes statistically meaningful. A 22-year-old has almost no independent financial decision history to evaluate. A 30-year-old, if they've been working inside the family structure since their early 20s, has roughly 7 to 10 years of observable behavior. How they handle a bad quarter, how they treat people with less power than them, whether they show up sober and prepared, whether they can be argued with. Family governance consultants describe this as the point where a trustee or a parent can make a control release decision based on evidence rather than hope. The cautionary tale argument. This is the one that shows up most often in the actual drafting rooms, and it's rarely spoken about publicly, though it circulates constantly inside the wealth management industry as informal case study lore. Families that gave heirs full control in their early 20s and watched significant portions of multi-generational wealth evaporate within a decade through some combination of bad investments, divorce settlements, addiction, or simple overspending. The shirt sleeves to shirt sleeves in 3 generations pattern we've covered before is the statistical backdrop here. A commonly cited figure holds that a large majority of family fortunes don't survive intact past the 3rd generation, though, and this is worth being precise about, the exact percentage varies significantly by study and methodology, and some of the most quoted figures trace back to surveys with real limitations in sample size and definition of survival. What's much better supported than any single statistic is the directional finding, replicated across multiple independent studies from different countries. Sudden, unstructured control of large wealth at a young age correlates strongly with poor long-term outcomes for both the money and the person. The second marriage argument. A less flattering but very real factor. Many staggered distribution ages are set with an eye toward divorce risk. Family wealth advisors will say, off the record, that a meaningful fraction of trust structures delaying full distribution to 30 or 35 are partly designed so that if an heir's first marriage doesn't survive their 20s, which is statistically a higher risk decade for early marriages generally, the bulk of the family fortune was never fully commingled into marital property in the first place. This is precisely why prenuptial agreements and trust distribution schedules are so often discussed in the same conversation, and it's a detail almost never covered in mainstream personal finance content, because it requires understanding both family law and trust law simultaneously. Why not sooner? Why not later? Set it too young, say 22, and you release control before there's any real track record and before the brain science supports it. Set it too late, 50, 60, and you risk the exact resentment and disengagement problem we're about to cover in Section 6. A fully capable adult with a family and a career of their own, still asking permission to access their own inheritance, which tends to produce exactly the kind of quiet, corrosive family resentment that estate litigators get called in to referee. 30 sits in the window that satisfies the actuarial logic without triggering the psychological backlash, usually. The anchor cases, how real dynasties built this to be responsible about this section. Specific figures inside living families' current trust terms are almost never public, and we're not going to claim inside knowledge of anyone's private legal documents. What is well documented through biography, journalism, and the family's own public governance materials is the general historical pattern across some of the most studied dynasties in the world. The Rockefeller model. The Rockefeller family is probably the most extensively documented case of deliberate generation-spanning trust architecture in American history. John D. Rockefeller Jr. worked with advisors to build trust structures for his children that explicitly staggered access to principal, and the family later formalized a broader governance structure, including Rockefeller Family and Associates and a family council model, specifically to manage the transition of both wealth and decision-making authority across generations far removed from the original fortune's creator. The Rockefeller family's much-noted survival as a functioning family enterprise across 6+ generations in a landscape where most fortunes don't make it past 3 is frequently attributed by family business researchers less to the size of the original fortune and more to this early, deliberate investment in governance, including exactly the kind of staged, evaluated access to control we've been describing. The Rothschild model. The Rothschild banking dynasty's control structure historically ran through partnership agreements that kept ownership and management extremely concentrated within a small number of family members who had demonstrably proven themselves within the bank first, a structure that, translated into modern trust and governance language, is the same prove it before you're trusted with it architecture, just built for an earlier era using partnership law rather than modern discretionary trusts. The Wallenberg model. The Swedish Wallenberg family, controllers of a vast industrial empire through their foundation and holding company structure, is one of the most frequently cited modern examples of formalized, merit-tested succession. Family members historically were expected to work outside the family enterprise first, in unrelated companies, before being considered for any leadership role inside it, and even then, entry into real control has traditionally required demonstrating competence to other family members and outside professionals, not simply reaching a birthday. The Wallenberg approach is often held up by family governance consultants as one of the more rigorous real-world examples of separating title from power on the basis of demonstrated readiness rather than age alone. The Fugger precedent. Even earlier, the Fugger merchant banking dynasty of 16th century Augsburg, which we've referenced before in our Japanese merchant dynasties comparison video, used apprenticeship structures that kept nephews and heirs working under senior family members for years, learning the actual mechanics of the business before any real authority was extended. The pattern is centuries older than modern trust law. Trust law didn't invent this instinct. It just gave old money families a much more precise tool for encoding it. The consistent thread across all four cases. The specific legal instrument varies wildly by era and jurisdiction. Partnership law, foundation structures, discretionary trusts. But the underlying principle doesn't change at all. Access to real control is a privilege that has to be earned through demonstrated readiness, evaluated by people who already hold power, on a timeline long enough to generate real evidence. Every family that has kept its fortune intact for multiple generations appears to have independently arrived at some version of this same answer. We go this deep into the actual mechanics, not just the aesthetic, of how generational wealth is built and protected in every single video on this channel. If that's what you're here for, hit subscribe and turn on notifications, because we post new breakdowns like this every week, and honestly, some of the best ones don't perform well in the algorithm early on. So, notifications are the only way you won't miss them. The psychological cost. Life inside the waiting room. None of this is free. The structural logic is sound, but the people living inside these structures pay a real, well-documented psychological price, and it's worth taking seriously rather than treating this purely as a legal curiosity. Identity confusion. Psychologists and family wealth therapists who specialize in working with heirs, a small but growing field, describe a consistent pattern they sometimes call sudden wealth without sudden agency. The heir knows with total certainty that enormous resources exist with their name attached. They also know with equal certainty that they cannot access or direct those resources. This combination produces a strange, specific kind of limbo. Too resourced to feel the normal motivating pressure of financial necessity that shapes most people's 20s, but not actually free to make major independent decisions either. Clinical literature on affluent families describes this as a contributor to what's sometimes informally called failure to launch syndrome among wealthy heirs. Though it's worth being precise that this isn't a formal diagnosis, just a widely used descriptive term among family wealth counselors. the authenticity problem. A recurring theme in heir interviews and memoirs, and there are more of these published every year as second and third generation wealth holders increasingly write and speak publicly about the experience, is the difficulty of ever knowing whether relationships, achievements, or even romantic partners are real in the sense of existing independent of the money and the eventual power that comes with it. A titled but powerless heir occupies a particularly strange version of this problem. They can't even fully test the "would this person like me without the money" question, because the money hasn't been separated from them yet. It's visible in the title, the office, the trajectory everyone around them can see coming. Resentment toward the gatekeepers. It is extremely common, again, according to family wealth advisors who work directly with these dynamics, for the heir's resentment to focus not on the abstract concept of the trust, but on the specific person controlling it, the trustee, the parent, the older sibling who already has full control. This is one of the most common sources of long-running family conflict, and it's a major reason the family constitution and family council model has grown in popularity, moving the "you're not ready yet" decision away from a single parent and toward a more depersonalized, criteria-based process feels, to many heirs, less like personal distrust and more like a system everyone is subject to, the performance trap. Because the title years are functionally an evaluation period, even if nobody calls it that, heirs frequently describe an exhausting sense of being perpetually on display. Every meeting, every public appearance, every choice of friend or partner, understood as data being collected toward the eventual "is this person ready" decision. This is psychologically distinct from ordinary career pressure, because there's no separate private life to retreat to. The evaluation doesn't clock out. What actually helps, according to the people who study this? The research and practitioner literature converge on a few specific mitigants. Transparency about the actual timeline and criteria, rather than a vague "when you're ready." Real decision-making authority over something, even a small discretionary budget or a defined project, rather than pure observation. And, perhaps most importantly, a role outside the family structure entirely for at least a few years first, which is precisely the Wallenberg model from Section 4, and which shows up again and again as the single factor most associated with heirs, later reporting a healthy relationship to both the money and the family. How families actually decide ready. So how does 30 actually turn into yes, now, rather than just a date on a calendar that arrives regardless? This is where the informal evaluation becomes formal, and it maps closely to what we described in our wealth test video. The unspoken vetting questions old money families use, just applied here specifically to the succession decision. Financial literacy under pressure, not in the classroom. Family offices increasingly test heirs not on whether they can pass a finance exam, but on how they behave during an actual bad quarter, a real portfolio drawdown, a real difficult negotiation, a real staff conflict. Composure and judgment under real conditions matter more than credentials. Treatment of people with less power. This shows up constantly in family office consultant interviews as one of the single most weighted informal criteria. How does the heir treat the driver, the assistant, the junior analyst? Multiple family governance advisors describe this as more predictive of long-term stewardship than academic performance or even investment track record, because it reveals character under conditions where there's nothing to be gained from performing well. Willingness to be told no, an heir who can accept a rejected proposal, absorb the reasoning, and come back with a better version, rather than escalating, sulking, or going around the person who said no, is treated as a strong positive signal across virtually every family governance framework we've researched for this channel. Outside validation. Success in a role outside the family structure. A promotion earned somewhere the family name didn't help. A business built independently. Even a demanding, unrelated career. Functions as powerful evidence, precisely because it's the one data point that can't be attributed to the family's influence. The formal proposal. In the more structured family councils, the final step before full control is often a literal presentation. The heir formally proposes a vision, a plan, sometimes a specific investment thesis, to the family council or the board, and is evaluated on the quality of that thinking, the way any outside candidate for a major leadership role would be. The birthday doesn't automatically trigger release. It triggers eligibility to make the case. This is the detail that reframes the entire topic. 30 isn't really a release date. It's an eligibility date. What determines whether power actually transfers on schedule, gets delayed further, or in some documented cases gets restructured entirely, is the evaluation record built during the exact years the heir was walking around with a title and no real authority. CTA 4, Pre-Conclusion, CTA, placed before final section. If you're finding this useful, the fastest way to support the channel costs nothing. Just leave a comment with one word, trustee, title, or test, whichever part of this structure surprised you most. It genuinely helps the algorithm understand this content is worth showing to more people, and I read all of them. What this means if you're building wealth, not inheriting it. If you're not from old money, this entire structure might read as a problem exclusive to the ultra-wealthy. It isn't, entirely. The underlying principle, that access to control should be separated from access to benefit and released gradually as trust is earned through evidence rather than granted immediately based on relationship or age alone, is exactly the same principle behind vesting schedules in startup equity, behind staged inheritance planning that financial advisors now recommend to affluent but not ultra-wealthy families, and increasingly behind how first-generation wealth builders structure their own estate plans once they have something meaningful to protect. The families we've studied across this channel who successfully kept fortunes intact for 3, 4, 6 generations did not do it by trusting each new generation completely and immediately. They did it by building systems specifically designed to survive individual failures of judgment, including their own children's, through delay, evaluation, and staged authority. If there's a single transferable lesson in the entire title without power structure, it's this. The people who protect wealth longest are rarely the ones who trust the hardest. They're the ones who built structures that don't require trust to work in the meantime. The heir with the glass office and the business card and 8 more years until the trust releases isn't being punished. She's inside the exact same architecture that kept her family's fortune alive long enough for her to inherit it in the first place. Whether she resents that architecture or eventually becomes its next architect is, in a lot of documented cases, the actual test. If this changed how you think about generational wealth, the next video in this series covers the black sheep protocol. What happens to the heir who never passes the test, and how families structurally manage the sibling who was never going to get the trust released, ever. Links on screen now and in the description. Subscribe if you haven't, and I'll see you in the next one.